Davidson County, Tennessee is now open to transact business for which it was created. All persons having business before this honorable court, draw an eye, give a petition, and you shall be heard. God save the United States, state of Tennessee, and this honorable court. The Honorable Mark J. Fishburne presiding, please be seated.
Good morning.
Good morning, Judge.
That's the first order. We'll just call the doctor.
Travis Reinking.
State ready?
State's ready, Your Honor.
Defense ready?
Yes, Your Honor.
I got two motions that were filed under seal from the state. Is there any motions that were filed by the defense?
No, Your Honor.
All right. Is there any issues about the two motion in limine filed by the state?
Your Honor, as to motion number one, the defense has no issue with motion number one, except to say unless the state were to open the door through any proof or questioning that they present as to issues of competency, we would have no intention to try to get into that subject matter.
All right. Now, when we say we're not trying to get into that subject matter, I take it you're not, like, you're going to present evidence as to his mental state as without getting into the issue of his competency.
Absolutely.
Yeah, I just wanted to.
Yes, Your Honor, that's what we understood. We've met with counsel any number of times,
Okay.
so don't believe, and there probably will be some questions that would be asked of the experts of, and what do you do for the courts? So that part of that, but getting into the the weeds about it
The opinion that he was actually incompetent
for a period of time.
No
Yes.
objection that he went to MTMHI and all that kind of stuff and was treated there and so on and so forth, right? I just
Correct,
want to make
sir.
crystal clear where we are.
That's correct.
Okay. In that case, basically granted by agreement with clarification that we've had today, this morning. What about motion limiting number two?
Your Honor, we've reviewed motion in limine number two. It appears to me more or less to be on its face a motion requesting us to follow the statute and the existing case law in Tennessee as it relates to the limitation on what the experts can testify to as to their ultimate opinion. We agree that that law is correct and have no intention of steering outside those lanes, so to speak.
All right.
And Judge, that's as we would have expected, and actually, main thing was, I like the line from the Hank Wise case. This is,
I was wondering why you cited Wise instead of like Flake and a couple of the others that are the Supreme Court ruled on, but.
well, because they say, in our opinion, it would have been less confusing had the parties addressed the permissible scope of the expert witness's testimony beforehand. So that's all. Yes, all of the case law, Flake and the other reported cases, I think are very, very clear, but it was just a way of getting before the court and on the record what the position is. And with respect
And we'll
to...
put it on the record clearly that you're following Wise.
Yes, Your Honor.
Because you are Wise.
Yes.
Okay.
Yes. And I was unwise to be involved in that case.
Okay.
But seriously, Your Honor, under Rule 703 and the anticipated proof, note that as issues come up, Your Honor would have to rule on those as they come, and discuss with counsel that perhaps, if Your Honor would like, to have the reports in hand to review. I know we won't get there probably for a couple of weeks, maybe.
It'd still be nice to have them. I haven't, there's been no discovery openly filed in this case. I don't have a clue what's in the file.
Yes, Your Honor. Yeah.
I can't even get my clerk to let me take a peek.
So in any event, Your Honor, yes, just so the court, as we go through, there may be objections, and if so, we would ask to approach the bench and before we get into any of that. But no, I think we're in agreement as to what the law is, and we'll endeavor to follow it. Did have a couple of housekeeping matters.
Sure.
With Your Honor, and counsel is aware of this as well. Count 2 of the original indictment had a misspelling, a typo in the spelling of one of the deceased names. And so by agreement, we would like to substitute. I have several copies. in other words, unstapled, take out the count 2 and put that in.
All right.
And that's all it was. It was
Get that done.
one letter left out. And just to put on the record, the state is going to take a nollius to count 17.
The just unlawful weapon possession.
Yes, Your Honor. Given the recent legislation that there's probably no crime under current law, and so it only being a misdemeanor.
All right.
I think that for clarity's sake, and I believe the clerk has already adjusted the indictment accordingly.
We will enter a nollie on count 17. Anything else?
As far as the jury questionnaire, I think parties are in agreement about that. And a question, at least that I had, was given the coverage of whether Your Honor intended to use the jurors' names or to have them referred to by their jury number.
I prefer, and I'm even in a case that doesn't carry much publicity. I've had jurors complain for years that their identity gets known and things of this nature. Unless there's an objection, I would prefer that we go by their jury number.
That's what the state would prefer.
Now, I have issued an order, and you should have gotten it last week, that prohibits the news media from publishing or otherwise broadcasting the names of any jurors. Did y'all not get that?
I don't recall. No, Your Honor.
Okay, well, I'll find out what happened. Oh, wait a minute, I think I may have just put it in, I think I sent it to the news media. If you didn't get it, I apologize.
Well, that's fine. That may appear odd than why I was talking about it. If Your Honor already
Yeah, I
issued an order.
apologize, I could have sworn it went to all the proper parties, but yes. So, numbers work for me.
Okay.
I guess we'll have to educate them on their little number, which is, I assume, the one that's on the master list.
Yes, Your Honor. That's what I would think.
Yeah.
And then, of course, that could be redone when they become jurors number 1, 2, 3, 4, 5.
And if you haven't tried a case, number 1C is top left, going left to right, and then 8 through 14 be bottom left to right. Okay?
That's right. And then I suspect the only thing that comes to mind is tomorrow morning that we go downstairs and Your Honor tells our prospective jurors what they're in for.
Yeah, and I'm going to send you just a little outline for you to look at. I mean, I'm not going to really get into much down there,
No.
other than this is what if you end up on this jury, just enough to explain to them, if you have a hardship, let's go upstairs and talk about it.
Yes, Your Honor.
Okay? So I'm not getting into much of anything beyond that. I will still have a court reporter down there just to cover all the bases in case there's a slip of my tongue and this type of thing. But I will send you just the outline that just to cover topics I'm going to cover so that there's no dispute, and see if there's anything you think needs to be added on that.
Okay, thank you, Your Honor. And with Your Honor,
And I will do the same thing for the hardships, and it's gonna be a hardship on a lot of these people, but, so I think I need to be a little bit more strict than might otherwise occur in a normal trial when people have a hardship. Otherwise, we won't end up with anybody. And so I'm kind of working on that as well, and I'll send that to you by email just to look at it and make sure, see if you got anything you want to add or subtract to it. So,
and the only other issue that I'm aware of, or really not an issue for the state, is Your Honor's email about the courtroom protocol.
yes.
The state has no objection or comment about
Any
that.
comments from the defense on that?
I think we just need a little clarification.
Sure.
On it, because it says attorneys will be required to wear a mask when approaching the bench, which obviously we have no issue with. I didn't know if that meant that while we're at the table, we don't have to be masked, or.
You don't have to be masked. I think there was a request made by,
It was.
so you don't have to be masked when you're at the table.
So basically, you want us masked, but coming in the building all the way till we get into the courtroom.
When you get in the courtroom, you get to your respective counsel table, you can take off your mask. If there's an objection that requires you approaching the bench, then you'll have to put your mask on.
Okay, we
All
understand.
right?
Thank you.
And pull out the portable podium just for a second
Yes, sir.
as to where we normally put it.
Yes, sir.
During,
We still have a problem with our playback system, so when they come to the bench, if they can be sure to talk into this.
I was just advised by the court reporter, and it'll go over behind the court reporter, it's got a small tape recorder up here, or if that's what they're still called, I don't even know what they're called anymore since they don't use tapes. But be that as it may, we're still having some difficulties when we put on the white noise. It's still interfering with the discussions that go on at the bench on a bench hearing. So he'll have the microphone, his recorder there. Just make sure you are standing close to the recorder when you talk so that he can pick it up. He or she, whoever may be here that day.
Judge Woody, perhaps now, could we, one of us approach, one from each side approach?
Sure. Tom, where are you gonna normally put that? Over here?
Yes, Your Honor.
I mean, all of you can kind of come up and look at. And I'm, just normally kind of lean forward like this.
That's the problem.
Yeah, kind of, and therefore it interferes with the sound, but recorder will be right there. Y'all can move closer.
That's what I didn't.
Yeah, no, you can come up to the bench.
Okay.
Come on up. That's why I want you to wear a mask up
That's-
here.
yeah. And
Okay, but that way you can, and if he punches you in the back, then get closer and speak directly into it. But it's pretty sensitive, isn't it? Tom?
Put you over on this end.
Yeah. Yeah.
Actually, Judge, there is something, we could approach the bench about.
Did you get any of that?
Yes.
With the mask, you gotta speak a little bit louder. All right, is there, anything else that we need to address this morning?
No, no.
Okay. I'll get these emails to you just to review it and, see if there's anything that, needs to be added, subtracted, modified, clarified, whatever the case may be, for tomorrow. And hopefully, we won't have, we had 190 who were supposed to show up. Hopefully, we won't have 190 hardships, but we'll see how it unfolds.
At least there, won't be any conflict with, a Sunday afternoon football game.
No, we don't have to worry about that. In fact, yesterday morning, I called a couple of friends of mine, and I said, what time is it that the Titans are supposed to play? Because they didn't play on Saturday. And I got a guy coming up here at 10 o'clock to get sworn in as an attorney, and he's really glad that, we had difficulty getting together, and he's really glad that we're doing it today because his parents are from Ohio, and they came down for the game. So I sent him the order about no paraphernalia with any insignias, wording, or anything else on it. Anything else? Thank you all very much, and we'll see you here. It'll probably be 9:15, 9:30 before we go down, because, it takes a while to get them all in the building, get them situated in there and stuff like that. So if you want one day, just one day, Ms. Norman, you can be here at 9 o'clock.
Thank you, Judge. I
All right.
appreciate that.
You get 30 minutes of extra sleep time, prep time, whatever you want to do with it.
Thank you, Judge.
All right, thank y'all. Have a good day, and we'll see you tomorrow.
Hey, John.
Yeah.
I was gonna give a report about downstairs. Mark said.
We're in adjournment. Y'all can go.
Mark says that, there's no way to hook up the sound system down there. So